All right, well, again, welcome to this event, What's in a Sentence. It's part of Victorian Law Week. I'd like to begin by acknowledging the traditional owners of the land from which I'm speaking, the peoples of the Kulin Nation. And I pay my respects to their elders past, present and emerging. My name's Ed and I'm the Media Manager at the County Court. I'll be moderating this event. If you have any questions for the panellists today, you can type them into the Q&A box at the top of the screen, or rather at the bottom, at any time during the event, and I'll relay those questions to the judges later on. But just note that we do have quite a few people viewing this event, so we will not be able to get to every question. On our panel for today's event is Chief Judge Peter Kidd, Judge Fran Hogan, and Judge Philip Coish. So I'll start with the Chief Judge. Chief Judge was appointed to the County Court of Victoria in 2015. His honour holds a Masters of Laws from the University of Geneva, where he specialised in international humanitarian and criminal law, and a Bachelor of Laws from the University of Adelaide. His honour holds a dual commission as a Justice of the Supreme Court of Victoria and sits on the Court of Appeal from time to time. Before he became the Chief Judge, His Honour had 20 years of experience as a criminal lawyer in Australia and overseas, mostly as a barrister and senior Crown prosecutor in Melbourne. In the mid-2000s, he took his family to Sarajevo, where he was an international prosecutor at the War Crimes Chamber of the State Court of Bosnia and Herzegovina. There he prosecuted war criminals arising from the Bosnian War in the mid-1990s. Chief Judge Kidd regularly appears on radio throughout Victoria and from time to time on national television, where he seeks to explain how the justice system works. Welcome, Chief Judge.
Thank you.
Judge Hogan was appointed to the County Court in 2001, having practiced at the Victorian Bar for 20 years. In her first 10 years at the bar, Her Honour practiced in both criminal and civil jurisdictions. In her second 10 years at the bar, she practiced exclusively in personal injury cases, specialising in medical negligence, and she was the first female barrister to successfully establish a practice in the male-dominated common law jurisdiction. And since being appointed to the bench, Her Honour presided over both civil and criminal cases for 16 years, but now sits exclusively in crime. Welcome, Judge Hogan. Finally, Judge Philip Coish was appointed to the County Court in 2002 after 20 years as a barrister. As a judge, His Honour has conducted a wide range of cases in the County Court over the last 19 years, including a number of high-profile criminal cases. Welcome, Judge Coish.
Thank you.
So we've got some questions to the judges to start off the conversation, but as we said before, please feel free to type your questions into the Q&A box at any time. And just a reminder, the judges can't comment on legal advice or any particular cases that they or another judge may have heard. So I might start off with the Chief. Chief Judge, maybe you can start by telling us a little bit about the principles and the purposes of sentencing in general.
Thank you, Ed. And can I just welcome everyone to it's terrific to have such a large audience with us today. At a general level, sentencing is something which is a challenge to all judges. We're required to follow the law and a set of principles. Judges just don't choose a number. And those principles can be broken up into roughly three categories. There are some considerations which are directed towards the general public, such as the requirement to ensure that the sentence amounts to or constitutes just punishment. So the courts must mark out its disapproval of the criminal conduct in question. There is also general deterrence, so that when a sentence is imposed, it deters others within the public from engaging in such criminal conduct. The other area which judges concern themselves with concerns victims. So the impact on a particular victim must be taken into account by the judge. And impact may be the physical harm and emotional trauma, or indeed in some cases the financial loss. So judges must give weight to that in the sentencing process. And the third area is really directed towards the individual offender. For example, their personal circumstances, their age, whether they have prior convictions, and an assessment of their prospects of rehabilitation. And judges must also make some assessment as to how they specifically deter that particular offender from offending again. So the sentence must operate as specific deterrents, if you like. In the end, it's a balancing exercise, so judges must balance all of these factors with a view to reaching a just and appropriate and fair sentence. Ultimately, the sentence is about individualised justice. It's individualised in the sense that it's directed towards the offence in question, the victim in question, and the particular offender in question. The law basically says that it's not one size fits all. That's why we call it individualised justice. So that gives you a broad thumbnail sketch, if you like, as to how sentencing works.
Thanks, Chief Judge. Very thoughtful answer. I might ask the next question of Judge Coish, and then I open it to the panel. We do get a lot of questions at these events about sentencing youthful offenders or younger people. Could you explain for the viewers what are the different factors a judge has to take into account when sentencing a young person in particular?
Yes, thanks, Ed. Youthfulness is an important consideration, and the primary focus of the judge when sentencing a youthful offender is on rehabilitation. The law recognises that rehabilitation is important. It can be of great benefit to the community generally and, of course, to the individual involved. The law also recognises that young offenders are often immature and their moral culpability may be less than that of a more mature adult. So the law takes that into account.
Excellent. Does the panel have anything to add on youthful offenders?
Perhaps I could add, Ed, that we've had some recent initiatives that have been put in place here at the court, which I think are going to be very useful in dealing particularly with youthful offenders, although one of them isn't confined to youthful offenders. We've got the Court Integrated Services Program called CISP, and that's a program of supervised bail which has been operating at a magistrates court level since 2006 as a pilot and then formalised in about 2009. We're now running a pilot in relation to that, and this is very exciting because often people can be really assisted by having supervised bail. They might be homeless, they might have mental health issues, they might have any number of really serious issues and a lack of support in the community because they're estranged from their family. And so what can happen is now, after an appropriate assessment, there can be, particularly in the context of a deferred sentence, an order of the court that a person engage with the Court Integrated Services Program, and this can help link them in with community supports, find them a place to live, sometimes work, drug treatment or whatever. And I think that's going to be very, very valuable because it's particularly young people who've fallen through the cracks that need to be picked up there. So that's a really exciting initiative. And the other recent initiative is our drug court, which is just starting to be run. So this applies in situations where there's a drug-related offence and the judge might be contemplating a term of imprisonment of up to 4 years. And what can happen is that there can be assessment to see whether the person is suitable, and if so, an order, a drug treatment order made whereby they engage for a period of time in dedicated drug rehabilitation and treatment. And I'm really, really happy to see this occur at the county court level. Again, it's been operative in the magistrates court, but so often we're really powerless to initiate very strong initiatives for rehabilitation. And so this is exciting because we might help some young people get off ice, and by the time they're sentenced, they'll have some plea material if they've cooperated with the drug treatment order. And it's really that they're sentenced to a term of imprisonment, It's just that it's to be undertaken by virtue of the drug treatment. And obviously, if they don't comply, there are sanctions and they risk going to serve an immediate custodial sentence. But that's a really powerful initiative, and I'm very happy that we've got that happening at the county court.
And I could endorse everything that Judge Hogan has just said. Terrific initiatives. Just on that question about the sentencing of young people, talked about by Judge Coish, it does highlight that the sentencing considerations sometimes conflict with each other. That's why it's such a complex exercise. Some considerations pull in the direction of a more severe sentence, and other considerations pull in the direction of a more lenient sentence. And we often see that with young offenders. Let's say a young offender commits an armed robbery. Well, an armed robbery is a very serious offence, especially if there's an impact statement from the victim who was traumatised by the armed robbery. That needs to be given full weight by the judge. So that pulls in the direction of a more severe sentence. Yet if the young offender is very young, let's say 18 or 19, they have no prior convictions, and there is evidence before the court that they have good prospects of rehabilitation, then it's in the interests of the community to rehabilitate that offender so they can participate in life as soon as they can as a constructive member of the community and not reoffend in the future. So some of those factors might pull in the direction of a more lenient sentence. And therein lies the great challenge for a sentencing judge. The judge needs to balance these considerations in order to reach that just outcome.
Thank you, Chief, and thank you, Judge Hogan, for that answer before. You have touched on the next question, Chief Judge, which is, I'd like to ask each panel member, what do you find the most challenging aspect of sentencing in your personal experiences?
Perhaps start with you, Judge Coish.
Well, perhaps if I could start by explaining the process. It's really a three-stage process in that the first stage involves a plea hearing. And at a plea hearing, the prosecution present a summary of the facts in terms of the offending. A victim will have an opportunity to present a victim impact statement, either themselves or it will be read by a prosecutor. And the defence will have an opportunity to put submissions before the judge and call, for example, character evidence or provide references and the like. At that first stage, there can be a number of difficulties. There might be a dispute as to the facts. There might be a dispute as to the role played by the offender. There might be a dispute as to whether various factors relied on by the offender in mitigation apply. For example, an offender might allege that he is mentally impaired. The prosecution might take issue with that. They might say, no, we don't accept that you were mentally impaired at the relevant time. So there can be a number of facts which have to be resolved following the plea hearing. In a complex matter, it'll be usual for the judge to take a little bit of time to reflect on the sentence. So that's really the second process, and that can involve a period of quiet reflection. The third stage of the sentencing process involves the pronouncement of the sentence. In a case in which there's a great deal of public interest, there might be a crowded courtroom and a lot of media attention, and it might be an emotion-charged event. On the other hand, on many, many occasions, sentencing will take place in a near-empty courtroom with a couple of barristers, a security guard and a prisoner. So in addressing the most challenging aspect of sentencing, from my point of view, the answer is it really depends. It depends upon the particular case that I'm dealing with.
Okay.
I guess the most challenging aspect of sentencing I find is where you don't get enough assistance from the bar table. There'll be various documents tendered, and there'll be a hint perhaps that there's been a history of some mental illness on behalf of the offender. And it's really frustrating when you have to try and tease it out. Because if someone has had a significant mental illness or cognitive impairment which has contributed to his or her offending, then that's an important factor to be taken into account in a number of ways. It may reduce the moral culpability of the offender. It may have an impact on the type of sentence to be given. It may make serving a term of imprisonment very onerous for that person, or it may actually mean that having a mental illness will become worse whilst in custody. So they're the sorts of things that you really need to properly be appraised of. Fortunately, when we're feeling somewhat aggrieved that we may not have been given as much assistance about a psychiatric or psychological history of an offender, we do have the power to order a psychological or psychiatric assessment from Forensic Care, which is a professional body, and that can be of assistance. But that's really frustrating, and it can often hold things up. It can mean there's a delay in sentencing because you have to adjourn the plea hearing so that the report becomes available. And that's hard for both the offender, but also often for the victims of offences, because they're wanting finality, they're wanting to try and pull their lives together after what's occurred. The other thing that I find hard about sentencing, and this has been very evident over COVID, is taking away someone's liberty over a screen. The bulk of people whom I've sentenced over the last 12 months when we've had pandemic restrictions have been people who have already been remanded in custody. They haven't been on bail. I think it's really important when you're sentencing someone to look to them, to speak to them, to try not to use language that's overly complicated so that they can understand why you are imposing the sentence that you are. And it's also important for the victims and the general public as well. But I've found that to be a Kafkaesque aspect of our life on the bench during COVID, not to be able to look into the eyes of the person and try and have them understand why it is that you've arrived at the conclusion, the sentence that you are giving.
Well, I would add to what the other two judges have said, every case is different and the challenges with every case vary. Some can be more distressing than others, especially in relation to the impact upon victims. Others, it can be very challenging when sending someone to jail for the first time, especially a younger person. But one of the things which seems to be a constant with most sentences is resolving what is ultimately a just and fair outcome in the particular circumstances of the case. Most of the questions that a sentencing judge must address are not black and white. They admit of no black and white answer. We have to engage in a value judgment, if you like. And in fact, Judge Hogan mentioned that there may be cases where an offender or his or her counsel argues that the offender was impaired to a degree mentally at the time of the offending. We as sentencing judges need to look at the evidence and make some kind of assessment as to the extent of that impairment and how much weight to give that in the sentencing process. And these are difficult judgments to be made, and they're just challenging intellectual judgments that we have to make. And sometimes, with some sentences, there are series of similar such judgments that we have to make in the process of reaching our ultimate decision. And I think that's a challenge that most sentencing judges face in most sentences.
Thank you, Chief. Thank you, judges, for those thoughtful answers. Just following on that response, I might ask you this, Chief Judge. There's often comments in the media where a sentence is handed down and a party is aggrieved by the sentence, generally a victim or a family member of the victim. Does this outrage necessarily mean that the presiding judge has made an error, or is it a bit more complex?
Well, it's definitely more complex, and it doesn't mean that the presiding judge has made an error. Judges sentence in the public interest, And by the public interest, I mean in accordance with these legal principles. And we need to balance various interests, such as the interests of the victims, the impact that has taken place with the crime, as I mentioned earlier. But we are also required, as a matter of law, to take into account other factors, such as whether the offender was impaired at the time of the offending, which might reduce their moral culpability. Now, I indicated before that there are some factors which pull in different directions, and that might be one example. You might have a victim, and I should stress that one can't generalise about victims. Victims in different cases may have different views about the sentencing process and the way the law works. But you might have a case where a victim in one case says, well, I really don't care so much about the fact that the offender was a young person or had mental impairment, and I don't like the fact that that offender is getting a discount or a lower sentence because of that mental impairment, or the fact that they're a very young person without prior convictions. That victim might say that it doesn't affect the harm that was inflicted upon me during the offending, and that's a very human response. But of course, the judging question must take into account the fact that it's a young person who's got good prospects of rehabilitation, or perhaps that the offender had less moral culpability for the offending, even if the victim disagrees with it. Now, there might be another occasion where the victim fully understands and fully supports the judge taking into account those factors, but ultimately, we as judges take an oath to comply with the law. And whilst we must give weight to the harm caused to victims, we must also take into account many other factors, and that's what the law demands.
Great answer. Thank you, Chief. Now, it's about time to move on to live questions from the audience, and I'll just remind everyone that at the bottom of the screen you'll see a Q&A box. You can type any question in there, and we'll do our best to get to it before the end of this session. I might start, because COVID is the topic of the day, of course. We have this very interesting question from Tanya. How will the any COVID-related court delays impact sentencing? And I think that's a very relevant question, given we've just been talking about mitigation and reasons why someone may receive a discount. Could the panel address that question? How is COVID affecting sentencing, if at all?
Well, I'm happy to answer that. We're obliged to take into account the more onerous nature of imprisonment under COVID, which starts with an initial 14-day quarantine period in isolation. It's been very tough for most prisoners because the out-of-cell time has been halved in order to facilitate social distancing, so they're stuck in their cells for lengthy periods of time. In addition, there have been no contact visits with family or friends, and that's what keeps the prisoners going, really, particularly with the long sentence, their loved ones coming to see them and bringing news. There has been additional supports by way of telephone and video conferencing, but it's not the same as being able to hug your partner or children, and that's been very tough. So the other thing that's happened is that hands-on programs, rehabilitation programs, haven't been largely available. So there's a terrible boredom factor, and it means that the aspect of rehabilitation that is capable of being addressed in prison, such as undertaking a drug rehabilitation course or some vocational skills or the like, just haven't been able to be addressed. So it's sort of really been hard for those prisoners, and we must take that into account. We also take into account the fact that they have pleaded guilty at a time when it's not been possible to run criminal trials in the state of Victoria. And so there's an added benefit, if you like, or discount given for that factor, because they could have strung it out knowing that there wasn't any possibility of a trial being run for some time, but instead they've accepted responsibility for what they've done. They've acknowledged their guilt, they've pleaded guilty, and the victims, if there are victims of the particular offence, have that consolation for what it's worth to them. So that's some of the ways that COVID's impacted on sentencing.
Fantastic, thank you.
Perhaps also I could just add that delay itself can be a factor in mitigation, but it seemed to me that the question might be directed to what's actually happening in the court on a day-to-day basis. And the criminal courts are still operating, pleas are being heard and determined, and an offender who does plead guilty will have their plea heard and determined by a judge within a relatively short time. So it's not as if plea hearings have stopped. Those matters are still being determined and have been determined by the judges of the county court throughout the pandemic.
And I should add that we have been conducting jury trials, criminal jury trials, since January. So we resumed within that COVID environment, and we're now increasing the number of those jury trials that we can conduct on a weekly basis. The only other comment that I would add is this question of an offender pleading guilty and that operating as a mitigating factor in their sentence. And by mitigating factor, it's taken into account in their favour. It's one of those factors that will pull towards a more lenient sentence. And the reason for that is that it's in the community's interests if people plead guilty, generally. There are a number of positive things for the community. Firstly, the offender usually is showing some acceptance of responsibility, which is a good thing. It also means that in many of those cases, victims do not need to go through the additional trauma of having to give evidence. And there's also an economic saving to the court and to you, the community, because instead of a 1 or 2 week jury trial being conducted, it's a one-day plea hearing. So there are many reasons why the law needs to encourage people to plead guilty, and it does so by giving them a benefit in the sentencing process.
Thanks for those answers. Now, I must say thank you to the audience because we've just been inundated with really thoughtful questions, and I can already tell we're not going to get through them today, but we'll give it our best shot. We've had a number of questions about the role of drugs and alcohol as evidence in the sentencing exercise. Several people have asked whether you can be found to be more or less culpable if there's alcohol or drugs in your system at the time of an offence. So I might just ask the panel, perhaps starting with the Chief, to just address the role of drugs or alcohol and those sort of substances in an offender's culpability, and whether it can increase, decrease, and what are the different situations that might occur in.
Well, I started today by talking about individualised justice, and one looks at the individual circumstances of the particular drugs or having consumed alcohol. The law doesn't, in that sense, recognise what one might think Dutch courage, or somebody going out and getting drunk on a Saturday night and then being involved in an assault. It's not an excuse, and it doesn't lower your moral culpability that you've been drinking. Now, having said that, there might be some cases, it might be an individual case where an offender, there's evidence that that particular offender what did particularly that person was able to demonstrate that they weren't going to drink or consume drugs like that into the future. That's something the judge would weigh up in determining their prospects for reform. So in that narrower sense, it might operate to the offender's behaviour. It's not the fact that the person was drunk or was intoxicated on drugs at the time, it's the fact that they were able to demonstrate that they're unlikely to re-offend again. So that's just one example.
There are occasions where it might be somewhat not strictly mitigatory, but less serious than in another situation. I suppose the most common example of that is where you have someone charged with and pleading guilty to drug trafficking. There can be a huge difference between the upper echelon of drug traffickers who are not drug addicts and are in it for profit and are running a sinister business to the terrible detriment of our community, and someone down the bottom of that chain or hierarchy of drug traffickers who themselves is pathetically addicted to some form of drug and may traffic in a way where they really just get their cattle or whatever the drug might be and separate it and mix it with something else and on-sell to support their own habit. So you can see that this goes back to what our Chief Judge said about the individual circumstances of the offender. Generally speaking, if someone is a drug trafficker and in it for profit, that's a serious aggravating factor. On the other hand, if someone has been drug addicted and has been engaged in trafficking, if by the time the plea hearing is heard, they've engaged in some serious rehabilitative measures which give the court some optimism that this factor in their offending is well on the way to being addressed, then obviously that will be taken into account for that offender as a positive factor in terms of their rehabilitation.
Yes, there is a bit of a view in the community that a person will get off because they were on drugs at the time, or they'll get a lenient sentence because they were drunk at the time. That's not the case. So a person might be on drugs at the time they committed an offence. That might explain their action, but it won't excuse their action. It's a very important point to make because we encounter a lot of offending where people are drug affected. For example, a lot of crimes of violence are committed by ice addicts. The fact that they're on ice at the time is not a factor in mitigation. So as I say, it might be an explanation for why they acted so badly, but it does not excuse their behaviour.
Yeah, that's right. And in fact, there can be cases where the behaviour is so violent, so irrational, so random, driven by being affected by a drug that it's an aggravating factor because they are incapable of being reasoned with. And that's really, really scary.
Very good point. I might stay with you, Judge Hogan, for the next question. We've had a number of questions about support available for witnesses, particularly children who might be presenting evidence in a criminal prosecution. Can you run us through some of the resources available to young people, vulnerable witnesses and the like?
That's a really important question. So thank you to whoever brought that up, because while technically it doesn't come within the sentencing ambit, it's normally within the trial process. We've got a couple of really important steps that have been taken over the last decade or so towards making it easier for vulnerable witnesses. First of all, in sex offences where you have a child, that is a person under the age of 18 years, or someone who's cognitively impaired, rather than having their complaint to the police written down in a statement, their story, if you like, is taken by a highly specialised police officer who will ensure that they don't lead the witness but try and ask simple questions that will best elicit from the complainant what he or she has said has occurred to them. That is called a VARE. It's an acronym for video and recorded evidence. So what is recorded by that person, insofar as they tell the police officer what's happened to them, becomes their evidence in chief at the trial, which is a fantastic initiative because years ago there used to be a long gap between when a child made a statement and when they ultimately came to court, and their memory could be eroded and they'd be picked up in quite cruel cross-examinations at times for giving inconsistent answers and that sort of thing. The other thing that happens with a child or cognitively impaired witness is that they then come to court to be cross-examined after their statement to police has been recorded. And that's what's called a special hearing. At that special hearing, the person can give their evidence from a remote witness facility, and that means that they don't have to see the person accused of committing the crime against them. That's important. Also, a recent initiative of the Office of Public Prosecutions is the provision of specially trained soother dogs for anxious witnesses who may be children or cognitively impaired people. And so obviously the person has to like dogs and be happy to have a dog, and the judge has to approve it. But these are specially trained, very gentle dogs who apparently have some sensitivity to levels of stress. And so, you know, the child or cognitively impaired person can be introduced to the dog beforehand, pat them, or the dog can actually pick up stress levels, which might mean that it's appropriate for that witness to be given a break. So that's an initiative that's really helpful for some people. The other important introduction in recent years is the concept of an intermediary. Now, this is where, again, we get a child or a cognitively impaired witness who might have real difficulty in getting their story across. What occurs is that the court orders a specially trained person, it might be a speech pathologist, it might be a psychologist or some other professional person who has particular expertise, to assess the child or cognitively impaired person, and that specialist then produces a report to the court detailing the areas of difficulty that that particular witness has. And it might be that they have trouble with complex language which contains multiple concepts, or they can only think in a strictly linear way. And so what then happens is that there's after the reception of that report, there's what's called a ground rules hearing, where the judge and the barristers for both the prosecution and the accused person get together, discuss the report, and try and make some rules about the style of questioning of the particular cognitively impaired or child witness, so that really you can ensure that the best evidence from that witness is given. And it might be just as simple as not using double negatives that lawyers are so favour. Did you not say to so-and-so, or something like that, or just breaking questions up into a simple form. And the intermediate can also act as a bit of an interpreter, which is handy. So he or she, through their skills, can assess when a witness is troubled or perhaps misinterpreting a question. So that's a really valuable initiative, which tries to even the fairness, if you like, for people who have particular difficulties when they're giving evidence because they're vulnerable, and that should be taken into account.
Excellent. We've had quite a few questions about both standard sentencing and mandatory sentencing. So I might start with the Chief Judge on this one. Firstly, just for the benefit of those who may not be familiar, what's the difference between mandatory sentencing and standard sentencing, and how do they apply to sentencing in general?
Well, they're very complex questions, so I thank the people or persons for asking those questions. Mandatory sentencing, perhaps I could approach it this way. I started today by talking about individualised justice, and that's where the judge tailors the sentence to the particular offence, to the particular offender, having regard to all of the circumstances, including the impact of the victim in question. What's just and appropriate in that particular case? That individualised justice process recognises that it's not one size fits all. One example, if I could just give there, I mentioned earlier an example of an armed robbery committed by a young person, let's say 18, with no prior convictions, and who's got good prospects of rehabilitation. Let's contrast that to the same type of armed robbery, but committed by a mature person, let's say 35 years of age, who's got a number of prior convictions for offences of violence and whose prospects of reform are very poor. Now, it's the same offence. Let's say it's an armed robbery on a milk bar, but the offenders are very, very different. And individualised justice demands a different outcome in both instances. As a matter of logic, the younger person with no priors, with good prospects, that person must necessarily receive a more lenient sentence than the more mature person with prior convictions and poor prospects. Mandatory sentence is the exact opposite of individualised justice. Mandatory sentencing basically says one size fits all. So mandatory sentencing in the circumstances in which I've just discussed would effectively demand the same outcome for both offenders. And it takes the capacity of the judge to impose a just sentence in each case away from that judge. So that's mandatory sentencing, and I'll perhaps turn to Judge Coish to give an explanation of standard sentencing. Otherwise,
yes,
you'll be hearing from me for too long.
Actually, I'm going to leave my seat for a moment, and I'm just going to get what's called the Sentencing Act 1991. So our questioner has asked a particularly technical question about standard sentencing. So the audience might be interested in knowing that the Sentencing Act is 585 pages long, and it contains the law that must be applied in relation to sentencing. And Parliament has said that in relation to certain offences, there is what's known as a standard sentence. There is a maximum penalty imposed in relation to every offence. The standard sentence is a proportion of that maximum penalty, and it ought to be applied. Now, that's in 10 words or less what standard sentencing is. It's a particularly complicated area in that it can be technically difficult. It's a good question because it does highlight one of the difficulties that arises in sentencing, and that concerns the technical aspects of sentencing. So in other words, if I could just expand on that, often offenders commit a number of offences. So we are discussing sentencing in a very general sense today, but we'll often, at a practical level, be dealing with an offender who might have committed 10 or 20 different offences. For example, somebody might break into 5 houses and steal 10 things, then steal a car on the way home from the last burglary, then be arrested and be in possession of drugs. Now, in sentencing the individual, we're required to consider each offence. So the sentence to be imposed on each offence must be corrected law, and we're then required to impose an overall sentence which is appropriate. And under our system, we don't just add up all the figures. For example, 2 + 2 + 2 + 2 in relation to each burglary or whatever it might be. We have to make an assessment, and this involves concepts of concurrency and cumulation. In other words, how much of each sentence is to be served concurrently together with another sentence, how much of a sentence is to be added on to a sentence. If we add into that mix the concept of standard sentencing, you can see, well, I hope our questioner can understand that we begin to deal with particularly technical aspects of sentencing. At the end of the day, the judge, however, is always concerned to arrive at just punishment. So standard sentences are a legislative provision which requires a particular starting point in relation to certain serious offences?
Great answer.
I don't.
And one example, for example, is culpable driving. I think it's 9 years, isn't it? That's said to be the standard sentence for culpable driving causing death, and obviously that's a very serious offence, and the judge must take that standard sentence, which has been legislated by Parliament, into account in the whole sentencing process. Perhaps just to differentiate between that and mandatory sentencing, some examples of mandatory sentences which have been put into effect because of community concern about prevalent offences and particularly serious offences. So these can be things like aggravated home invasions, where you'll get a group of people invading someone's home, often in the early hours of the morning. They'll be armed with weapons and there are people present in the home. That is an example where there is a mandated term of imprisonment and a minimum term, I think it's 3 years, that must be served unless exceptional circumstances can be shown. Another one is assault intentionally causing injury in circumstances of gross violence. And again, this would be a situation where there's a group attack on an individual who's disabled, someone who's literally down and still being kicked and punched, and serious injury is intentionally caused to that person. And I think the mandatory minimum for that is 4 years, unless one can demonstrate exceptional circumstances. So that is Parliament taking the community's concern about these prevalent offences into account. It does make it difficult for judges, but there is always the exceptional circumstances situation. So, for example, if someone was found to perhaps be on the fringe of the offending, albeit equally guilty as a group offender, had pleaded guilty early and also informed on the other co-offenders who may not have been known to police, then that might, in combination, represent exceptional circumstances in that case as to why that person shouldn't be given the mandatory minimum term. I hope that helps explain the difference.
Can I, just to circle back, with mandatory sentencing, as Judge Hogan said, it's a creature of statute. Parliament makes it, and in fact, in our Sentencing Act, it's qualified because Parliament allows for certain exceptions. But if you don't qualify under those exceptions, then the sentence is mandated here in the sense that if it's a mandatory minimum non-parole period of 3 years and you don't qualify under the exceptions, then your non-parole period must be at least 3 years. Standard sentencing is a goalpost or a guidepost, if you like. It's one further factor that the judge needs to take into account. The judge can depart from that standard sentence, can go below it or above it, as the case may be. It becomes one of an additional factor that the judge must take into account, alongside things like the maximum penalty, the plea of guilty, prospects of reform, etc. It becomes one further factor which goes into the mix, of the balance, if you like. So in that sense, it's different from a mandatory sentence, which actually requires a minimum sentence to be imposed.
Thank you for those answers. We're almost out of time, so I think we may just have one or two more questions. But one thing we have been asked about a lot that we haven't touched on yet, we've obviously spent a lot of time talking about mitigation and those sort of matters, but sometimes a judge will have to hand down a sentence that could only be described as crushing, in the 20-year or above range. Can you just explain why that might sometimes be necessary and why rehabilitation might fall to another sentencing principle?
Well, perhaps I can go first in that, in the sense that I have sentenced an individual to 25 years imprisonment. The maximum penalty was life imprisonment, and I did indicate to that offender that but for his plea of guilty, I would have sentenced him to life imprisonment. So he did receive a discount by virtue of the plea of guilty. The 25 years imprisonment was in respect of large commercial quantity drug trafficking and importation. The factors that are involved in a case of that nature are the circumstances of the offending. So this was a large-scale international drug syndicate. It involved sourcing drugs overseas, it involved importing drugs into Australia, and then it involved a distribution network within Australia. And the courts have consistently said that those engaging in that type of drug trafficking must expect stern punishment, heavy penalties. In a case of that nature, the overwhelming magnitude of the drug syndicate's operation was the primary factor in my mind. And I think I perhaps could also indicate that that case was one of a series of cases I did over a 6-month period involving a major federal police investigation, a major Commonwealth prosecution, and there were trials and pleas in which various participants in the syndicate were arguing about their role. Role is an important consideration. So a case of that nature does, in my view, require stern punishment. It also highlights the fact that in the county court, we're dealing with a range of cases, and we are dealing with very serious criminal activity, and on occasions it is necessary to impose stern punishment.
Great.
Yeah, I think that what's evident from what Judge Coish has said is that those very big sentences are really a reflection of the gravity, the objective gravity of the criminal offending. Another example could be, for example, if someone had either through showing off struck and killed a pedestrian and then continued driving and didn't stop and then killed another person, either another driver or passenger in another vehicle, and gone on to maybe do some hideous property damage by crashing into someone's house, that overall gravity of offending would be very high, and you'd be looking at a very stern sentence for that. So when you get those sorts of sentences, the offending is really very, very serious.
So, sorry, go ahead.
The only thing I'd add is that in the county court, very sadly, we had a lot of sexual offence cases here. In fact, it's some 50% of our work, and many of those sexual offence prosecutions involve offending against children. The sentences imposed for that kind of offending are very high. And the law requires us to, as Judge Hogan and Judge Coish said, to take into account the objective gravity of the offending and to publicly denounce such criminal behaviour, and that criminal behaviour is denounced through the imposition of the sentence.
Fantastic, thanks for those. So we're coming up to time, but I just want to squeeze in a question about the effect of the media on sentencing. And I might just, if you could start the Chief Judge, and then I'll open to the panel. What effect does the media have when considering a sentence?
Well, the media certainly would not influence a judge in relation to the imposition of sentence. The courts are independent of the media organisations. In fact, the courts are independent of all organisations and institutions, including government. That's a really important part of our democratic system. The only factors which a sentencing judge will take into account are those factors which the judge must consider in accordance with the law. which, as Judge Coish pointed out, is contained very largely in a very thick piece of legislation and also against the background of the common law. So if a matter is a particularly high-profile matter and is attracting a lot of attention, it would be quite improper for that to influence the judge in the way in which the sentence is handed down. That's not to say there might be some instances where the particular person in question has been vilified in the media, which may, in the particular circumstances of the case, may amount to some form of additional punishment, and in that indirect way, the judge may be required to give that matter some weight. That's a very different thing from the question, which I think is really about, would judges be influenced by the particular narrative which has been pushed by a media organisation or the media generally? And the answer to that is no.
It would be contrary to our oath to be influenced by media or a surge of public opinion, whether they be people demonstrating outside the court. But having said that, the media have a very important role to play, and we here at the County Court, particularly under Chief Judge Kidd and your good self, Mr Gardner, have tried very hard to engage with the media to ensure that they have sentencing reasons available to them promptly. So most judges in crime, when they're sentencing in a matter, will ensure that what we call our audio portal is used, so that journalists or reporters who can't make it to court will have access to that, so they can listen to the reasons for sentence and hopefully get it right, and not just pick out the more sensational sentences that a judge might have uttered. The other thing is, if it becomes apparent that it's a particularly newsworthy scenario that's the subject of sentencing, a judge will try to ensure that the sentencing remarks are all in a form that can be made readily available on the internet to journalists and via our media panel. So we're very conscious that, by and large, the courts are open and the media do have to have access to what's said in courts. And if it weren't for the media, to some extent, we wouldn't be able to get the message of general deterrence, which means sending a strong message that this sort of behaviour will not be tolerated and will generally result in a significant term of imprisonment through to the public. So the media do have an important part to play in that sense.
Do you have anything to add to that, Judge Coish? Or?
Well, I have a confession, Ed, in the sense that I've kept a scrapbook. So, but having said that, no, the media don't influence me in any way, but media provides a wonderful opportunity to enable the court to get its message across to the public generally.
Fantastic. It's certainly a topic that's probably worth a bit more in-depth discussion, which is why on Thursday we'll have a media and the courts panel, which will be a similar format to this with some of our most experienced judges. And you can find all those details on our website. That's actually all the time we have. So I thank the panel and I thank the audience for those fantastic questions. Every year they blow us away with just how insightful and thoughtful the questions we get are. So thank you again. Before we wrap up, I just want to add that if you go to countycourt.vic.gov.au/law week, you can see the full program of panels that we have for the week. We have some really interesting opportunities available. If you know someone who couldn't make it today, or you want to review any part of this session, this will be published on our website, the full recording. And if you're interested in any more information about the common criminal offences that the County Court deals with, we have a criminal offence portal on our website where you can see what are the average sentences and lengths of imprisonment and those sort of statistics of things like culpable driving or sexual offences. Particularly of interest to VCE students, we feel. So head on over to our County Court website and you can find that information. Once again, thank you very much to the panel. Thank you to everyone for attending, and that concludes the event.
Thank you.
Thank you.